Good evening, friends. Amongst us, it gives us immense pleasure. We have Mohit Mathur, a known name in the field of fraternity of law and beyond. Similar and akin to our sessions of Beyond Law CLC, his way of hammering the points, projecting the same, has always been well received amongst the bench and the bar. And therefore, when we all talked about, we read that judgment wherein the Honorable Supreme Court recently said that what is the way forward to understand the things, how you have to make the appeals, how you have to prepare it, what are the points of presentation. As they say, that art of filtration of facts and law, and once you are in a criminal appeal, how to marshal these evidence. These all aspects have their own nitty-gritties, which with the flux of time one learns. But if they say that if you have a good guru, and especially in the days of virtual era, who can make you understand those things, is the best way forward. And despite the fact that he's the president of the Delhi Bar Association, Delhi High Court Bar Association, and a senior advocate with the practice, I've been trying to connect with him. Normally, his associates were being connected. Yet, his passion to pay back to the society speaks volume. And without taking much time, I'll request Mr. Mohit Mathur, who has joined with us, to take the session forward, make us understand. And for the audience who are watching us live on the YouTube, Facebook, and those who are connected with us on the Zoom, large part of the session would also be in Hindi, because we have been trying to take that process forward, only with an endeavor so that people can understand things in the right way. We had been receiving requests कि भाई sessions थोड़ा mix में हो जाए तो बढ़िया है, और मोहित माथुर जी की जो कमान है अंग्रेजी और हिंदी में उतनी ही है, और ये भी जान के खुशी हुई कि बाद में he had some roots connected with the Chandigarh, and therefore they say that I cannot say the like-minded meets, but like-minded, yes, for the purposes of sharing knowledge, do definitely meet. That is the common essence. And as they say that, I was just hearing one of the sessions of Kunal Shah, the cred owner. He said that friends are just like the dotted lines. They connect and they make the lines. And in that process of making lines forward, I'll request Mr. Mohit to share his knowledge, insights, and we are all eager to hear about that. Over to you, Mr. Mohit.
Thank you, Vikas ji. आपने ज़्यादा ही तारीफ कर दी. I don't know whether I am actually deserving it or not. But yes, you are right. After a few years in practice, one starts feeling कि अब एक time है where it's not, I would say, payback time, but it's time कि जो आने वाले लोग हैं वो भी इस institution को संभाल के रखें if we have to continue working. And we want this institution to work. So I hope कि हम उस चीज में contribute कर सकें. With that, I had requested विकास जी कि मेरे को ऐसा ही टॉपिक पसंद आता है जिसको हम अप्लाई कर सकें, क्योंकि लॉ तो all of us know, सबको पता भी है, किताबों में मिल भी जाएगी, सब ढूंढ भी लेंगे. Only question is presenting it and articulating your points in a manner, जैसे अब सुप्रीम कोर्ट ने कहा कि क्रिमिनल अपील को उनके सामने कैसे पेश किया जाए. तो with that in mind, if I may be permitted to say कि appeals under criminal law would generally be of two types. One, where the appeal is against a conviction. Second would be an appeal against an acquittal. There is a very narrow area, और बहुत ही एक छोटा सा अब नया डायमेंशन आ गया है अपील्स का, जहां स्पेशल स्टैट्यूट्स में they have made all orders and judgments to be challenged by way of an appeal. So I'll just keep that as the last part, but by and large we are dealing with appeals jahan pe we are talking of either challenging an order of conviction or an order of acquittal. appeals in the hierarchy of courts are generally either an appeal from a magistrate's court to the Court of Sessions, or from the Court of Sessions to the High Court, or lastly from the High Court to the Supreme Court. Supreme Court in that recent case, जो विकास जी ने भी mention किया, Justice Chandrachud or Justice Suryakant wala, where they said, and they asked the counsel to articulate the appeal in a manner in which they can understand it more as a story. And they asked the counsel to basically marshal the facts. In criminal law, we are dealing with two very important aspects in any case. One, the factual part of it. And secondly, what's the human behavior with regard to such situations? Because it's the reaction of the human mind and the human himself which actually makes the criminal law, the case, how it is put up and how it is prosecuted. To understand that, I would always feel that what the Supreme Court has said, and it is just now being discussed more, actually was always the case, and that's how always a criminal appeal needs to be addressed before the court. In the trial courts, the cases come up as the first point of evidence and discussion and appreciation of that evidence. Please, every counsel should bear it in mind that when you are in an appeal court and you are addressing the appeal court, there is a presumption of the judgment of the trial court or the court below, which is under challenge, to be proper. So you are in an appeal, basically, though it may be a statutory appeal or a special leave to appeal, the basic bedrock is that the court in appeal is presuming कि नीचे वाली अदालत ने जो फैसला दिया है, it is proper. So you will have to marshal your facts and the law in the points in your favor in such a manner that the court is basically taken by you through the facts and the law to your favor. तो आपको एक इस तरीके से कोर्ट को चलाना पड़ता है कि कोर्ट doesn't lose interest in your case and doesn't digress from the point you are taking. Because if you allow the court to digress from your chosen path, then you are in for trouble. And one of the difficulties which is faced is हमारी एक टेंडेंसी है कि हम अपील में सारी चीजें क्लियरली लाते नहीं हैं, और थोड़ा सा प्लीडिंग्स में भी, though it is not a mandate that you should plead properly, but it's a good reckoner. एक आपके pointers तैयार हो जाते हैं. When you write the grounds of your appeal, you can elaborate it later, but when you draft an appeal, you draft and put in the points so that later on, जब आप कुछ अरसे बाद जब वो अपील बहस पे आती है, and when you see those points, then you are able to understand. This is on the academic side, but on a practical side, सबसे important aspect which I have learned over the years is narration of facts. Please, everyone should bear in mind, every lawyer should know, an appeal court can reappraise evidence. So if it is a reappraisal of evidence, what needs to be told to the court is more of fact and not what the trial judge has done. और उसकी एक प्रैक्टिकल प्रॉब्लम है. अगर आप ट्रायल जज के ऑर्डर के हिसाब से पढ़ेंगे तो the trial judge or the impugned order, if I may say, impugned judgment जो है, that impugned judgment would be taking and appreciating and presenting the same fact against you. So rather than giving the court the presentation of a fact which is tainted or written in a manner where there is a semblance of things going against you, it's always better to give the facts from the evidence straight away. The way I learned it was, and I have been presenting it, is always in a form of a flow chart of first the timeline, what the initial case, how it unfolded, how the events unfolded to become the case. That in a criminal appeal, how did the first point of information came? Were there different diary entries, the GD entries, general diary entries? क्या information पुलिस में सबसे पहले आई? क्या पहला स्टेप था जो लिया गया? उस इंफॉर्मेशन के मिलते ही what did the police do? How did these steps unfold? That narration of the timeline is important to put in the mind of the court how the picture against you was created. Because if you have to assail that picture at a later point of time with the evidence, the court must know the unfolding of the events, especially with the chronology. Second aspect, which while narrating facts to the court is concerned, is one must explain where and at what places, what point of time, the important steps, which are the statutory steps in the process or in the criminal procedure code, have taken place. The court in appeal must be apprised that this is the background. That background or narration of facts is important because unless and until the court is aware of what the facts are, there is just no point in trying to apply or push what the law is without the facts there, because law cannot operate in vacuum. That we must know and we must understand very, very clearly. This is similar even if you are trying to challenge an acquittal, then also you have to inform how promptly things were done, what promptitude was there, and narration of the initial complaint, etc. So either which way, the narration of facts must come from the respective evidences. What have come before the trial court must be informed to the court in the appeal, so that you can assail the impugned order at a later point of time. Appraisal of evidence is the stage where you thrash out your arguments, but the factual matrix needs to be known to the court. और अगर आपने एक टाइमलाइन सॉर्ट ऑफ चीज बना ली तो कोर्ट के लिए आसान हो जाता है इन अप्रिशिएटिंग फैक्ट्स, आपके लिए आसान हो जाता है इन रिलेटिंग द फैक्ट्स टू द कोर्ट, एंड अगर कोई क्रॉस रेफरेंस करनी हो तो वो भी आपके लिए आसान हो जाती है. दूसरा, it's an unsaid thing. If you are narrating the facts properly and you have marshaled the facts properly, एक जनरल टेंडेंसी कोर्ट में वैसे ही आपके फेवर में ये आ जाती है कि दैट द काउंसिल बिफोर मी इज प्रिपेयर्ड फुल्ली, एंड वंस यू आर प्रिपेयर्ड फुल्ली, you are not likely to dither from where you are standing. You know your point and you would be able to handle all that is put to you. That's the practical side of it, because that bias comes ke bhai prepared hai. Before we start pointing out deficiencies, we must also prepare a chart of the evidence. And when I say a chart of the evidence, is that you have in your hands a list from PW1 till the last PW, anything important in 313 statement, or thereafter the defense evidence, defense witnesses. हर witness की क्या relevance है? That should also be, the names and the relevance of that witness should also be a ready fact, which you should just as a story narrate it to the judge that PW1 is so and so, he is relevant for such and such purpose, PW2 is relevant for such and such purpose. This is, उससे एक idea ये लग जाता है that the court need not and you need not waste your precious time on irrelevant witnesses. And when I say irrelevant witnesses, certain witnesses are just formal witnesses in the course of the process of collection of evidence before the trial court. उनकी अपनी evidence इतनी important नहीं होती जितनी हो सकता है जो वो document उन्होंने collect किया हो, लाके रखा हो, वो important हो. Then you must be able to marshal out that these are the key witnesses whom I wish to emphasize upon. Once you have laid down this chart or before the court, the next step comes in what are your basic points. And those basic points, it's always better, depending upon the case, आप की witness को की statement testimony पढ़ने के बाद you must give the time to the court to absorb your point. One of the common mistakes is you have a valid point, but you speed it up so much or you dwell on it so much that you don't let it get absorbed in that succinct manner in which it should go. तो कभी कभार हम अपनी उत्सुकता में और इतने आतुर हो जाते हैं बताने में कि हम बार बार एक ही चीज को 3-4 बार ही बोल देते हैं, तो जज का इंटरेस्ट लूज हो जाता है उस चीज में. दूसरा, कई बार हम इतनी जल्दी उसे ब्रश असाइड कर जाते हैं कि वो उसको एब्जॉर्ब ही नहीं कर पाता कि आप उस पॉइंट को क्या डेवलप करना चाह रहे थे उसकी एविडेंस में से. तो द नेसेसरी पॉजेज इन योर रीडिंग ऑफ द एविडेंस, one must be very, very careful, and the homework should be so prepared that rather than letting the judge sleep over the key part, take him to the actually the important part only. And this becomes very important in the serious cases where the testimonies of so-called eyewitnesses or the investigating officers are very important, and sometimes also important when you want to challenge on the points of when the issues are on the contradictions. तो contradictions को आप highlight तभी कर सकोगे जब आप वो points को you ensure that the judge spends the requisite time on that aspect in comparing the testimonies of the people you wish to rely upon. At the same time, इसी point पे मैं इसलिए ये बात भी बोलना चाहूंगा because in an appeal against acquittal, sometimes you want to emphasize upon the point which the judge in the impugned judgment has overlooked. So those aspects also, unless and until you are cautious enough to tread slowly and gradually on in your appeal, you just might skip it and miss it. Reading of evidence to the court is also necessary because you are in an appeal wanting the learned appellate court to reappraise it. जैसे हम लोग वैसे ही commonly कहते हैं कि two views are possible, then the benefit should accrue to the accused. तो जब reappraisal appeal में allowed है, तो evidence पे ध्यान देना बहुत जरूरी है और उस evidence को project करना in your way, because you just might be able to convince the appellate court the other way of looking at the evidence. Before 2009, appeal against acquittal में इस चीज की हमारे पास गुंजाइश बहुत कम थी. It had to be really perverse. But today, with the victim's rights coming in, the concept of victimology coming in, and a statutory right of appeal being given to the victim under 372, even at the appeal in an appeal against acquittal, a reappraisal is possible and reappraisal can be done provided आप उसको उसी तरह से project करें. While reading evidence, another part which is important is breaking the testimony into the parts and those areas. जैसे एक ही testimony, एक ही PW के 3-4 aspects के लिए वो relevant है और हो सकता है उसका एक aspect जो आप उसको question कर रहे हो in the superior, in the appellate court, वो किसी और के निस्बत है. Second aspect एक चौथे विटनेस के लिए रेलेवेंट है या डॉक्यूमेंट के साथ कंपेयर करना है और एक तीसरा पार्ट उसका जो है एविडेंस का वो किसी और चीज के साथ आपको प्रोजेक्ट करना है या आपको अननेचुरल कंडक्ट दिखाना है विटनेस का. इन अ केस जहां मेरी फैमिली मेंबर को अटैक किया जा रहा है और मैं भाग जाऊं, तो दैट्स एन अननेचुरल कंडक्ट ऑफ अ विटनेस. दोज एस्पेक्ट्स तो आपको वो दिखाने पड़ेंगे अलग अलग करके. सो आई ऑलवेज कॉल इट ब्रेकिंग द टेस्टिमनी इनटू कंज्यूमेबल पीसेस. ये मैंने एक अपने लिए बना रखा है तरीका सोचने का कि दैट आई ब्रेक द टेस्टिमनी इनटू द डाइजेस्टेबल पीसेस, द कंज्यूमेबल पीसेस. कौन सा किस चीज जगह पे रेलेवेंट है. एंड व्हाइल डिस्कसिंग दिस टेस्टिमनी, it's also relevant sometimes to emphasize on the human psychology, the human behavior, because mens rea in criminal law has a very important role. And you would find umpteen number of judgments which talk of the fact of the testimony, whether the testimony is reliable, unreliable, credible, incredible, on the basis of what is before you, how a normal prudent man would react, how a prudent person would react to a given situation. So since that is one of the issues, it's always better to break the testimony into smaller parts and read in juxtaposition compared to each of the parts, that the point that you wish to raise. Rather than reading one, एक गो में आपने सारी testimony पढ़ ली और फिर आप उसमें से दिखाने की कोशिश करो कि जी PW2 ये कहता है, जी 4 ये कहता है, 6 ये कहता है. It doesn't give the right flavor. It's like कि एक ही चीज को आप पेश करने का तरीका जो है वो तश्तरी में आप सारी चीजें इकट्ठा डाल दो प्लेट में. It may not look that beautiful, but if you put it and decorate it in the garnish it on your plate, all those things in a manner which is pleasing to the eye. Similarly, your articulation of an appeal should be pleasing to the ears. It should not be coarse. It should not be hoarse. It should come out in a very, very smooth fashion. जैसे सुप्रीम कोर्ट ने कहा कि tell us like a story, that you should tell it to us like a story. That I think they use the word like a fiction writer. Now, what they actually meant was that when you present a case, it starts setting into your mind and fitting the place. So the entire puzzle, it starts fitting into the smaller pieces, start fitting in. These are basic aspects where the factual part is then told to the court. I have always advised my junior colleagues or whomsoever has ever asked me कि जब आप प्रेजेंट करते हो तो इतनी हेस्ट में मत रहो कि सिर्फ मेरी सुन लो. Wait for the reaction, which is a very important aspect in an appeal, because you have an uphill task. You are assailing a judgment. And in Supreme Court, the task is even bigger for the reason that there are judgments there are two courts below who may have gone against you. So when you are approaching an appellate court, you must wait for that reaction to come so that you can answer it and not leave any doubt in the mind of the judge unanswered. And reason is, जो trial में benefit आपको है of a doubt going in your favor, appellate court में the doubt will not go in your favor because there is a judgment against you. So you must address all possible doubts that come in the mind of the judge or are likely to come in the mind of the judge. You must concentrate on the aspect of how the judge is reacting to what you are presenting. So if you are presenting the facts and the judge has a query coming, it's always advisable that you wait for that query, respond to that query, and then proceed further. This is a very, very common anomaly that we tend to rush into our scheme of things and our notes. We just want to skim through it and we feel that we have dumped everything with the judge. The judge should now filter out. So this filtration should happen simultaneously. And if I may be allowed to say, you should be able to control that filtration because you want the judge to look in the perspective in which you are looking at your matter, because you have challenged an order and you want him to look at it in a different perspective, which the trial court or the first appellate court may not have looked into. So in the appellate stage, you must, what we were told when we started our profession was, handhold the judge into and lead him into the direction in which you want him to go. I know it's easier said than done, but still, that is what the endeavor must be. That is what the endeavor should be. And that's the only way an appeal can be taken care. Next comes, in an appeal, is an important aspect of highlighting, barring the inconsistencies in the evidence, also the inconsistencies of the facts of the case with law. And a very, very recent example which happened with us in a case, the post-mortem report was silent on the cause of death. Since it's a matter which is still sub judice in the sense that the order has not been pronounced, but the minute this was highlighted to the court, that in a case of homicide, the cause of death has not been ascribed, the reaction changed. That how, under law, will you bring an act which has not been seen by anyone, with no eyewitnesses? How would that fall under homicide unless and until there is an explanation? Without an explanation of the cause of death, or without an expert opinion on the cause of death, how do you justify the conviction? That's just on the aside. It's a matter still, it's awaiting judgment, so I don't want to say anything further on it. But these are the points of law which you will need to raise after you have gone through the evidence and the judge has absorbed the evidence which you want him to appreciate, how you wish to show it to him. I'm reminded of a case long back, sometime in the early 90s, where in Supreme Court, they questioned the point that when the police, as I said, when you have narrated the fact on the issue of what is an first information report, is the first information report necessarily to be the one which has been transcribed under 154 in the police diary as the FIR, or could it even be a police report or any information recorded by the police, received by the police, on which the police has acted? That was a case where the counsel argued that first information means the first information. If the police has acted upon it, then that becomes the first information report. So on that legal point, the Supreme Court appreciated and held in the favor of the accused that the first information was the one which set into motion. Because if the narration of facts were such that the unfolding of events had started with the first information received telephonically on the by the police, and they started their process, the investigative process, then it doesn't need to be transcribed in the form of a 154. It should have been, but it had not been, doesn't matter. That becomes 154. So these points of law, if we start giving the judge that this is tuck, 1, 2, 3, these are my points of legal propositions, the interest doesn't arise in them unless and until you are able to hit with the evidence, and then you compare. It's compared with the law, with the facts, and then there is a better appreciation of the same point, which the appeal court should, according to you, because you are the one who's impressing upon the court to consider it and then react to it in your favor. So because you want him to react to in your favor, you got to keep hand holding him. Don't let him go stray into a territory which may suddenly become uncomfortable for you or inconvenient for you to answer. If factual aspects you have covered, then bring in the law. Because then the interest in the judge, the query in the judge has already awakened. It has risen. Once it has risen, then the judge will come to your side. There is a directional change which will happen because he started thinking in your favor. I just received a message. Mr. Chatra, should I respond to it right now? Do you want me to respond right now to this? Somebody is asked about highlighting about an appeal in acquittal in an abatement case.
We will take the question at the end. Otherwise, that entire link will go.
Okay.
For those who watch the YouTube, they will understand that the questions are taken at the end of the webinar.
Okay. 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 Thank you. So, facts first as the chronology, evidence thereafter as recorded in the court. And I just missed out one thing. While you have read out the evidence and before you step onto the law, if there are certain omissions in the prosecution case or conducting of the case by the prosecution, that should also come when the evidence has come, because there may be evidences which ought to have been recorded and have not been recorded, or may have been that the police has collected evidence or material from people whose signatures are appended or who have tendered that evidence, but they have not been examined in court. So all those omissions also in the evidence must be informed to the court at that point of time itself when you are narrating the evidence and relating the evidence and mentioning the facts. Reason being, it also highlights at that point how there has been lack of fairness in the conducting of the trial. We all know fairness in trial is also an important aspect which needs to be seen at the time of an appeal. If the court ever feels that there is lack of fairness in trial, that itself has sometimes been a ground to set aside the judgment and send it back, remand it back for retrial, or sometimes even for that aspect to be covered, additional evidence to be recorded, or sometimes the acquittal takes place. I distinctly recall a case where the mother of the prosecutrix was a key witness. She was the first informant. She was as far as her 161 statements were concerned, were very important and considered during the point of charge. However, when the trial took place, she was not brought. Court held that omission to be as an adverse inference under the Evidence Act against the prosecution, because there were certain aspects that she alone could have covered and she had not come to the court. So if there are omissions also, you must inform the court at the time when you are relating the evidence that X, Y, or Z have not been examined, though cited as witnesses or otherwise. Similar is the case when you are in an appeal against acquittal. One may insist that those who could have proved the case against the accused have deliberately been not examined. So it's entirely how you put it and how you want the judge to see it. So you need to project your case in a manner which suits you. And the perception, your perception of evidence or your reading of evidence or your understanding of the evidence is what you have to convey to the court and impress upon it. So that's the basic outline that one needs to understand when you are dealing with an appeal. There have been certain cases where I have had occasion to deal with some, I would say, abysmally low in percentage, but very strange situations. There are two provisions in the chapter on appeals which hardly come to anybody's attention. One is section 379. That was incorporated only in this act, in this code in 1973. It was not there in the earlier code. And that was a case where a trial court acquittal is reversed by the High Court and a sentence of life or death is awarded. Then there is a statutory appeal to the Supreme Court. It's not like an SLP. Though it's a very few, I think, stray cases, far and few, but it's something that one should, as a criminal lawyer, know. Another very important aspect, which we sometimes overlook when we are dealing with a case of multitude of accused, and that's that if there is a person who has come to you whose case falls under 375 or 376 as far as petty cases is concerned, or only on the if he is pleaded guilty. So one would feel that there's a bar that you cannot go and appeal. But please check if there are other accused and if there is an order or judgment passed against them, which is an appealable judgment, then even the right to appeal accrues to you. Though as per the sentence, it may be a petty case for you individually, but it is not so. So therefore, that aspect of right of appeal under 380 gives you the exception to 375, 376. Another part which I would be missing out if I don't say is a number of times you would find that there are more than one people who have been convicted or whose appeals come together. So there's a group of appeals, 3, 4, 5, or whatever. There is a tendency to go as I, me, myself. If you are in a joint trial and you've been convicted in a joint trial, my advice has always been to analyze first who is in conflict with whom and to what extent. There is a general tendency of the prosecution will be to pit you against the other. But you need to see how best you can avoid any kind of a passing on the buck in just arguments. If the evidence is to your inuring to your benefit, And only if the evidence is inuring to your benefit should you start on that track. Otherwise, sometimes it becomes a difficult proposition where a number of people are there. The judge is sitting in appeal, has not seen the demeanor of witnesses, has not seen the demeanor of the accused in his court. So he tends to see what is happening in the arguments. Now that is a very tricky position, because counsels may want to impress upon their case while probably rubbishing the case of the others, unless and until they sail together or likely to sail together. So it's very important to marshal out who all fall in what category, and then probably in a categorized manner, one can compartmentalize your arguments and present the case. Like if two people have almost a similar role, or if there are 2-3 people who have a likely conflict, then they should refrain from adding fuel to fire, but keep their arguments to the evidence which is before the court. That allows an objectivity in both the arguments as well as in the appreciation of evidence. If we try to add to it, embellish by making insinuations or passing the buck or putting the blame onto somebody else, then that doesn't help in an appeal, because it only goes on to show sometimes that it is possible that all may have conducted this kind of a act. As I started by saying, there is a element of certain special statutes. There are appeals which are emanating out of special statutes. And more so recently, you would have found even bail orders coming out of criminal appeals, which are something like in UAPA or something of similar nature, where the challenge is straight in a criminal appeal from any order. In fact, even in a domestic violence act, it's now an appealable order under section 29. Similarly, in UAPA, it's an appealable order. There, the emphasis on your testimonies may perhaps not be in the same manner in which I have discussed, though they may be, in terms of technically, they may be appeals, but we are actually not dealing with those appeals as appeals, except that the court has the power of an appellate court, which means that it's not restricted to any kind of a story where you are not dwelling into the facts. Basically, you can go into facts, and to that extent, the court is allowed to go into facts, and that's why the character of the challenge is of an appeal. But let's not confuse those things. Those are very few, though often these days one would see that division bench is taking care of a UAPA bail application, but that's because of the statute. Those are statutory appeals. So I don't want to unnecessarily waste the time here of everyone understanding those special statutes and the appeals which arise out of that. Something why I re-emphasize is we must understand that when we are talking of a criminal appeal, by the very nature of criminal law, it deals with deprivation of life and liberty. So the sincerity, the diligence is underlying. It has to be there. It doesn't need to be emphasized. So when we are dealing with an appeal, we must ensure that the liberty of the individual is not taken away without him getting the best chance And in the justice system, criminal justice system has to be balanced, affording him the opportunity which Constitution guarantees him. So as counsels, the duty is far bigger on us. One, our appeals should be prompt. We don't delay, because a person's life or liberty is at stake. Two, we should have collected all evidence before we, all material, all papers relevant. Three, we must find out what was initially pitted against him, what came during the trial, and how it has been gone against him. So to challenge and assail that, you'll need to understand all that. Also, what is required is that the first appeal, by and large, is his statutory right. And when it is his statutory right, he must be given that right properly. And sometimes for that, an extra effort needs to be done. If during the course of appeal you get information or material which must be brought to the notice of the court, then applications under 391, if necessary, for adducing additional evidence should also be moved. And there are cases and cases and cases where the courts have allowed additional evidences to be brought in an appeal stage also. Though in an appeal stage, normally the courts are reluctant, but if you are able to show that there's going to be a travesty of justice, that the justice itself is going to be denied to that person merely because he did not have the ready infrastructure or resources or the right advice to bring those pieces of evidence before the court, which could have probably tilted the scales in a different manner. So considering all that, I always emphasize that one needs to see all those things and present it in the best form of a bouquet, or you may call it like presenting really a delectable plate of goodies before the court, to tempt the court and to impress upon the court to accept your version and your perception and your understanding of the evidence, so as to basically accept what you are saying. So these are the basic things which are required in an appeal and to present the appeal. Thank you so much for your patience. I hope I have not overstepped the time limit.
Be that as it may, we are all lawyers. They say that it's my brief and it still runs into hundreds of pages. Number one. And number two, since a lot of suggestions were coming that we should speak in English, but the way you had mesmerized, I thought that let it go with the flow. And be that as it may, once you go in that particular mood and the way it has been received on the YouTube, I can just see that people have actually loved it. And they say that the taste of the pudding lies in the eating. And I believe that those who have today, actually, they could say that the pudding was too good. You have beaten all the master chefs. And like what you rightly said, everybody has those same products. सब्जियां वही हैं, मसाले वही हैं, बट उस खाने को कैसे प्रेजेंट करना और खाने को कैसे स्वाद बनाना है, वो उसमें ही है. जैसे हम वो सुनते हैं खाने में नानी के नुस्खे और माँ के नुस्खे, वो आपने जो आज नुस्खे बताए हैं, वो मेरे को लगता है वो लोग स्वादिष्ट भोजन संडे को डिनर तो करेंगे ही करेंगे, पर वर्चुअल डिनर एक बहुत लेविश प्लेटर हो गया, जैसे बफे हट या कहीं और का भी बारबेक्यू नेशन का उस टाइप का बफे है जो पीपल एंजॉय करते रहेंगे. मीनवाइल अब जो एक क्वेश्चन आया है, वी कैन टेक दैट. This is by Venkatesh Motha. He was saying that, sir, can you highlight about the appeal and an acquittal in an abatement?
I think Mr. Kota wants to say that the charge and conviction is of abetting of an offense. Now, there are two kinds in abetment also. One would be where the abettor is the only accused, and there would be cases where the abettor along with the person abetted is also an accused. If I am the only abettor, then I need to show from the material that what my conduct and my act was did not actually indicate towards doing of that act, because then you have to split the ingredients of the offense against you. The offense in abetment is requiring the instigating, aiding, or somebody to do that act. So if as an abettor, maybe I would say abetment, maybe if you are the only an abettor is there, then probably it would be something like abetment to suicide or something, where the person who tries to commit the suicide was not the, or who did commit the suicide is not the offender. He's no more there. So in a case where only the abettor is the offender, then he has to basically divorce himself from the act, because his conduct and the act will have a bridge. That bridge has to be broken. So he has to show that there is, and that's why I said when you narrate facts, you show by the timeline how the act has happened. But he has talked of an appeal in acquittal in abetment. So if it is an acquittal which has happened and you are the person who is assailing that acquittal, then your role is to show how his act actually was the act which immediately was the reason for the offending act to take place. And that's how the abettor can be roped in, because the abettor can only be roped in if it is in close proximity to the act abetted. So if the acquittal has taken place, you'll need to dig in for the evidence, and the way the timeline, as I said, that you draw a timeline which will show how, say at 9 o'clock something happened, then at 10 o'clock something happened, at 10:05 there was this duel or a feud or some kind of a tiff which prompted somebody to act at 10:10 and then 10:15, and then how the unfolding happened. So once you show that chain is intrinsically linked, then you will be able to challenge the acquittal, because the acquittal would have happened only by saying that the person's act has not instigated or aided. There is a snap. So you will need to build that snap, bridge it, and show that there is no snap. That's by and large the principles of presenting an appeal remain the same. Only thing is the ingredients, different ingredients are there of different offenses. So whenever you're dealing with that specific case, you'll need to cover that up. I hope that answers Mr. Kota.
Question, what was posted on the YouTube was, we can all say that the appeal is akin to the post-mortem of the case. You have to delve more.
I don't agree with that. I in fact say that appeal is the second opportunity for the lawyers to both make their money as well as to give their insights and perceptions again. They had their chance in the impugned order, and they now have the chance to represent it. In a post-mortem, we'll only be ripping it apart. The ripping apart is not necessary. That's what I have tried to say all along. You don't need to rip it apart, everything. You need to go simply and show your perception, because it is a reappraisal of evidence. Post-mortem would be probably a too harsh a word.
So meaning thereby you say that once you dive deep, you will get the pulse and you can save the person. So Mohitji, session as I earlier said, it was all mesmerizing. And there was a lot of demand that the session would have been in English. Be that as it may, I will just ask you, since you're so thorough and your entire focus was how to funnel the facts, how to focus the fact in a pyramid structure. If this session was to be in English, and I just asked you to sum it up, how you have to make an appeal in just 5 minutes. For those who have missed the other way around, let's have it in 5 minutes in an English. That what all has to be done.
As I started, I'll repeat it. Appeals are of 3 categories. 1, appeals against conviction. 2nd, appeals against acquittal. One can easily say that these constitute almost 95% of criminal appeals. The other 5% of criminal appeals are those which are under special statutes where you are allowing different orders to be challenged. But those are only in special statutes which provide for the only redressal and only challenge is under an appeal. So by and large, focusing only on the appeals of against acquittal or conviction, I had started by saying that the recent judgment of Supreme Court, where it talks of asking the lawyer, what was reported was the judges asking the lawyer to narrate only the facts and like a fiction writer, don't lose sight of the fact. So what I had started by saying was that that's only reiterating what has always been the version. Appeal is different from any other challenge. Appeal is a statute providing you a reappraisal of evidence. So the court can, on the same set of facts and evidence, find a different judgment. A different conclusion can be brought on that. So you are talking of reappraisal of evidence. So if there is a reappraisal of evidence, if we want the judge to look at the evidence in the manner in which we want him to look, because we are challenging and assailing the findings of the trial court or the first appellate court, it is imperative for us to don't let him stray on the trial court judgment or the impugned judgment. Reason being, every judgment has its own reasons. And once reasons are given, this is a way of looking at the evidence. So rather than allowing the appellate court to look at the evidence in the manner in which you want, you will be giving him the fodder to look at the evidence in which the impugned judgment has looked. So to keep him under check and handhold him across the path, you need to keep it to the way in which you want him to look at. For that purposes, one must marshal the facts. And facts must be so marshaled that, because in a criminal appeal, you are talking of an incident that has happened. An incident which, how it unfolded, how the event unfolded, and not just that, how things have been recorded in the evidence. So you'll need to take the judge through, say at 9 o'clock, so-and-so is stated to have said this or done this. And at 9:15, information reaches the police. At 9:20, the police party leave their police station and go to the spot. At 9:35 or 9:40, they reach. This is the first thing that they recorded. This is the DD entry and the how it was recorded and information sent by the PCR or the police or whatever. So that narration must have a time flow. Once you have and that in your grip, you are unfolding the events to the judge, you are basically trying to relay a story. You are creating a picture before him, a drishyam before him. So when you are creating that picture before him, you are going to have him see it in your way. You would want him to have, because you are going as per the evidence and you are telling this is the evidence and how the evidence has brought out the unfolding of the facts. In the meantime, you'll have to intersperse this narration with the important steps that take place under the process. The process could be the CRPC process, or what the normal, like going to a hospital or getting the MLC, then the doctor has examined and the doctor has sent him for an X-ray, or doctor has sent for stitches or something, anything of that sort. So the process could be either those prescribed under the CRPC or procedure as prescribed under the normal process which takes place in human life. So I said at that point of time that this narration is a must, because then the judge also is convinced that this storytelling that you are doing is culled out from this volume of evidence which is before him, and he starts trusting your way of looking. That's the practical side of it. If you are so well versed with the facts, the judge is convinced. See, law always takes a back seat when the facts are there. Law cannot act in vacuum. Law has to act on facts. The law is there, already there. It is the appreciation of facts which comes in. And when you narrate the facts, and you will be telling it in your own version, articulating it in your own manner, you will also intersperse it with the human behavior. What is necessary? What is the mens rea required? Whether I had the animus to kill the person, whether I had the animus to hit the person, whether I had the animus to cheat the person, all those things will start flowing A, B, C, D, and in that the stream from Gangotri till Bay of Bengal will start flowing in that fashion. After that comes your leading the person to the evidence. What's the evidence? In the evidence, I had said that you will need to check the omissions also, what the prosecution should have done and they have not done. So take care of those omissions also and inform the court that this is where I have not had a fair trial. So I am challenging that there is unfairness in trial. I'm constitutionally entitled to a fair trial. Then comes trying to interpose the different evidences and the aspects of what's the inconsistency in testimony. Besides the inconsistency in testimony, you will also show if the testimony of a person, how it is belied otherwise by documents, etc., by the exhibits which are there. In this entire exercise, I said that I have developed as a habit over the years, breaking the testimony, that a particular person, a particular witness may be relevant for 6 points. I don't believe that a person should continually read from the page 1 till page X, his entire testimony, just like a storybook and the end, and then keep it aside. No, you want your appeal to be heard. You want to show how you are right, your understanding of the situation is right, and the impugned judgment is wrong. So you break the testimony into comfortable, convenient, consumable pieces. You pick out that part and then juxtapose it with the relevant ones to show and highlight your point. That's what I had mentioned. And the human reactions and human behavior, because that's mens rea is an important aspect in criminal law. You will need to show how something is incredible or something is unbelievable or something is incorrect. All those aspects will come in at that time of your argument. So don't bring in your argument as a cart before the horse. It has to be the horse first. Give the facts, then carry the load of your arguments. Your arguments will hit the nail on the head once the facts have been absorbed by the judge in the proper manner, in the manner in which you want him. I believe that is what I had said. And I had also said Please bear in mind that as an appellate court, there is a presumption in appeal. There is a presumption that the impugned order is valid and is right, is justified. So you have an uphill task. So when you have an uphill task, save your breath and then go slow. Wait for reactions to come from the court. Because if you rush it or you make it very dreary and a drudgery, you will lose the impact. That's on the practical side of it. Obviously, each one to himself, how you wish to point your case. That's what I said. I hope, Mr. Chatrat, that summed it up.
I was just reading one of the, I was watching one of the sessions of The Art of Storytelling by Ms. Palki Sharma Upadhyay, the Beyond editor part. She speaks very well and she says, art of storytelling is katha ko acha kathakar samjhaye. The art of storytelling can be done only when who's a good storyteller. And I can vouch upon that. You're a good storyteller. And it is just like what Sanjay told to Dhritarashtra and Mahabharata. The same way you have mesmerized people. And this question
there is a query IVA.
That was I was reading. Lokesh says once the victim gave hostile witness in rape case and case was disposed of in court. Is there any chance to reopen or any legal remedies?
Not just an uphill task. I think an uphill climb. If the victim herself in the rape case had gone hostile, then I think she'd need to first cover her tracks and find out and give a justifiable reason why she lied to the court. She is the victim, and if she is herself not coming out clean, how do you expect any superior court to believe her unless and until she comes out and says, these were the compelling circumstances, these were the situations where I had to do it. And you're talking of something like Zahira, the Best Bakery case. It has to be that gross that the situation was that there was no option for the person to do anything. You'll need to basically, you are touching that extent.
The second question we will take, and that will be the last question because normally people keep on asking. The next question would be to the effect that in a normal case, we always find that people want, young students and lawyers also want to understand that further for understanding of any bail application appeal, whether you have to first read the Bail Acts and statutes or they should read the judgments to understand that this way, as they say, at the right time, you have to find out the 10 mistakes. It's an appeal also where you have to find the deficiencies. How to do about it and how to go about it. What do you say whether the young lawyer should first understand the bare perusal of these sections or from the judgments he should carve out that this is the way to understand the statute?
Vikas ji, I have always told my own junior colleagues and even those who interned with me that law will come. But first, any junior, any case, be it civil, criminal, anything, must know the facts of his or her case. If you don't know the facts, there is no point in reading any judgment or understanding the judgments or the law. You may be the best person knowing the law. You may rattle the law left, right, and center. But if you cannot identify that law with your facts, you will lose out. And recently we did that in one matter in which the prosecutrix had challenged and said about incest by her relatives. She complained of that, though they are facing trial. They went on 436 capital A, saying that they have suffered half custody. Now the question which the court saw and understood, they took out a judgment, and they brought the judgment to the court saying that if he has done half of the lower part of the sentence, it was from 3 years to 7 years. So if he has done less than half of the lower part, then he should be given. The judge in the High Court was almost inclined, reading only that head note and that part. We got hold of that judgment, we read that judgment and showed to the judge, one, in rape cases, the sentence is up to life. So life, the only fraction is, if you calculate life as 20 years, is 10 years, half of it. Second, 436 capital A leaves aside life and death cases. And that judgment, thirdly, was a case where the trial had been going on for 9 years. So it was, you have to read the facts. Without facts, there is nothing. The case is not built on law. Case is built on facts. So that's my advice to everyone. If even these youngsters who are doing civil cases, but you need to know the facts of your case. The judge wants to know. There's a presumption that the judge will know the law. Guide him on the law later if he's not going by the law. But give him your facts. What's that discretionary relief that you want? Bail is a discretionary relief. You want discretionary relief from the judge. You give him the facts.
Point well hammered. And often we find in the judgments, we often find and quoting that the judgments are not statutes. In fact, judgments
Absolutely.
are on the interpretation of the statutes. It may be a different connotation that judgments, whether the interpretation, we have a judgment of Honorable Mr. Justice Suryakant, where he speaks of in Dr. Mehta's judgment, what type of interpretations are there, textual interpretation, contextual interpretation, liberal interpretation. So that judgment, for the understanding of young lawyers and lawyers, that judgment of Dr. Mehta is very judgment which explains the contours of interpretation. And as you rightly said, that we have to first understand the facts, apply the statutory provisions, and then third comes the position where you have to apply the judgments. These are the three pyramids what I've been able to understand and gauge from whatever insights we have got from you. And thank you, Mr. Mohit. It was such a fascinating session. It was mesmerizing.
Thank you so much. Thank you for allowing me to come.
No. I often say that when the speaker is good, कि अभी ना जाओ छोड़ के दिल अभी भरा नहीं. So we will keep on calling upon you, and we will always remember another song which says "Mud Mud ke na dekh," but we will always say that you will have to "Mud Mud ke dekh" and give your sessions out here. Thank you, everyone. Stay safe, stay blessed. Thank you.
Thank you.
Namaskar.
Thank you.